Hi everyone, I'm Pratibha Agarwal. I'm an immigration lawyer. I'm based right outside of Washington, D.C. in Arlington, Virginia, and I am here today to answer your immigration questions. So I am streaming live on both Facebook and on TikTok. And my handle is at Agarwal Immigration on both Facebook and on TikTok. So make sure you like our page, follow us. And if you know other people that might have immigration questions, just a reminder to share this with them so they can hop on and ask questions also. All right, I'm going to start off with our question of the day, and I'll be taking your questions. So while I'm talking, feel free to put them in there, and I'll go ahead and answer them as soon as I'm done chatting. Okay, so the question I have today is something that we kind of get once in a while, not too often, thankfully, because it could be detrimental to your immigration case. So we do a lot of cases where one person in a marriage is being abused by their spouse, right? So it could be a man, it could be a woman, and they are usually out of status and they're being abused by their green card holder or US citizen spouse. So these are called VAWA cases, so Violence Against Women Act cases. It's a little bit of a misnomer because men can qualify, children can qualify, parents can qualify, so it's not necessarily just women, but those are the types of cases. So usually for us, the applicant is married to a U.S. citizen or a green card holder, and they're a victim of abuse. And again, it's not always physical abuse. Many times it's severe psychological abuse, verbal abuse, lots of shouting, name calling, controlling behavior, and those types of things. Okay, so one of the questions we get is, can I get remarried if I filed a VAWA application and I met someone else while my application is pending? Can I get remarried? The answer is absolutely not. Absolutely not. You cannot get remarried while your application is pending. That is considered an abandonment of your VAWA application. So do not get remarried if you have a VAWA application pending and you meet someone. Go ahead and date them, but wait until after you have a green card to go ahead and get married, because your application will not be processed if you get remarried. Okay. On the other side of that, right? On the other side of that is I have a VAWA application pending, right? So again, these are people that are married to US citizens or green card holders. They're filing for a green card based on abuse, right? So the other side of that question is, can I get divorced if I have a pending VAWA application? Can I get divorced if I have a pending VAWA application? Yes, you can absolutely get divorced if you have a pending VAWA application. This application is based on abuse, and no one is going to fault you if you need to be divorced and separated from your spouse in order to survive, essentially, to live without the mental and sometimes physical torture that is present in these types of cases. Okay, so divorce from your abusive spouse is okay, but remarriage is going to result in a termination of your application. All right, give us a call if you have any questions. We are at 703-348-1663. Again, that's 703-348-1663. All right, great. So I'm going to say hello to you guys. Feel free to say hi. I have people streaming on multiple platforms. Feel free to say hello. Let me know who you are and where you're watching from. All right, so we have Harsh here. Harsh says, I'm on a work visa in the USA and my fiance has a visitor's visa and she's planning to come to the USA for marriage. All right. Any suggestions? Well, number one, the intent requirement is a little bit problematic here, Harsh, right? So when you come on a tourist visa, you're supposed to have the intent to go back to your home country, right? So the first thing I'm going to say is you need to be very truthful on your application and in her responses to all of the questions at USCIS when she, not at USCIS, at the embassy when she goes in for the interview. So if she's abroad She's going to be going in for an interview. If she already has a visitor's visa, she can come in, and whenever CBP asks her any questions, she should be honest and clear in her responses. Okay. And she should only, I would say, only answer what they ask. You don't need to provide like lots of additional information if it's not related to the question that you're being asked. Okay. So when you come in on a visitor's visa, you have to have the intent to leave the United States after your brief visit. So your permission to come into the US is really just for that brief period of time. You're not allowed to just come here and stay in the US for any extended periods of time. Okay, so that it could be, that's the reason for you to not be allowed to enter. Even if you already have the visa and you're coming to CBP, if you say anything to suggest that you're going to overstay your visa, you will not be allowed to enter. All right. Okay. So that's one thing. The second thing is if she's already has in her head that she's going to come in and get married, that could be a problem, right? That could be a problem. So technically, she's not supposed to have in her head, right? She's not supposed to have in her head that she's going to come in and get married. Unfortunately, that's the case. She's not supposed to have in her head that she's going to just come in and get married. Okay? She can come in thinking that she's going to leave, right? She has a round trip ticket. She has a job abroad, but she got swept up and they decided to get married. That's okay. But if she comes in with the intent to get married, that is not considered okay. So she can't immediately come in and get married. But if she waits a few months, I would say at least 3 months, and then gets married and has a good explanation of why she came in on a tourist visa with the intent to leave, but really, ended up getting married, that could be considered okay. All right. Give us a call if you have any questions on that. We can be reached at 703-348-1663. I'm not sure what this question is, so I'm going to skip it. King says, what do I need to provide if I'm a U.S. citizen? Sorry, I'm sorry. Okay. We have another Harsh here asking a question. So all of our questions are coming from Harshes today. It's saying, my wife is out of the country and I applied for her green card. What do I need to provide if I'm a U.S. citizen? Right. So if you're a U.S. citizen or a green card holder, you can sponsor someone whether they're in the U.S. or whether they're abroad. So what do you need to provide if you're a U.S. citizen? Just remember the process first is to apply in the U.S. to get approval from USCIS that you can sponsor someone if they're located abroad. Okay, so if you're a U.S. citizen, what you need to show that you're a U.S. citizen is, one, if you're born in the country, you can provide your birth certificate. If you're not born in the country, you can provide your naturalization certificate, your U.S. passport. So all of that is considered okay. All right. I think I answered those questions. Great. Okay. One other question I wanted to bring up here is if I want to file a VAWA application, right? This is again for people that are married to U.S. citizens or green card holders. If I want to file a VAWA application, do I have to make the decision to leave my spouse? Do I have to leave my spouse? That's asked a lot, right? Sometimes people in abusive relationships need the confidence and essentially bravery that comes with having a green card in order to be able to leave their spouse. So within VAWA, so if you're filing for a green card based on your application, based on the fact that your spouse is a U.S. citizen or a green card holder who is also abusive, you don't have to make the decision yet to leave them. You can later if you choose to, or you can, decide to put your foot down and work on your marriage to make that marriage better and stronger. But You do not have to make the decision necessarily to leave your spouse. Okay, you don't have to make the decision to leave your spouse. You can still stay in the marriage. You can have children. You can do that, and you will have options, additional options, once you have your green card. If you wanted to leave your spouse. All right. Give us a call. If we can help you with your VAWA application, you can reach us at 703-348-1663. All right, here. Hi, Idaho. Nice to see you. Great. Another question is, how do I prove abuse in a VAWA case? All right, let me repeat that. How can I prove abuse in a VAWA case? I don't have proof of abuse. So most of our clients have not made a police report because a police report is not required. All right, a police report is not required. So most of my clients don't have a police report. So how would you prove abuse if you've never reported your abusive spouse to the police? You can prove abuse by a detailed declaration. So for our clients, we schedule a call with them. We get all of the details of the behavior of the spouse, the nature of the marriage. Of course, everything has to be factual and truthful. But we get all of your experiences, you tell us, we take notes, and we help draft a declaration that you can review and edit, where we kind of outline all of the details of the abuse. Okay. And that is almost always the only piece of evidence that is submitted. Some people have abusive text messages. Some people have police reports, hospital records of being harmed, maybe even therapist evaluations of them. But most of the time, we're seeing approvals, we're seeing cases winning with just a detailed declaration that we help you draft. Of course, during consultation, we will have a conversation and make sure that you qualify for a VAWA case. But most of the time, those are the only types of evidence, only type, I guess, singular, of evidence that we see. All right. Feel free to call us if we can talk to you. We can walk you through the process of how to apply for this. If you do qualify for VAWA, remember, you would receive a work authorization in about 6 to 8 months and a green card in about 2 to 2.5 years. So this is a green card application and a way to apply for a green card. So people in abusive relationships do not feel stuck, that they have an avenue to gain independence and freedom from their abusive spouse. Okay, call us 703-348-1663. All right, so Harsh says, if we got married after a minimum of 3 months, can she change her status within the U.S.? Yes, Harsh, you can change your status after you enter the U.S. You wait 3 months and she gets married. Yes, you can. But technically, the rule is that you cannot have that intention in your mind when she enters the U.S. So technically, if she comes in and says she has the intent to leave, but really has the intent to stay, and that gets discovered, then of course she will be barred from any type of relief or immigration benefit in the U.S. So she'd be permanently barred for misrepresentation or fraud. So the risk is pretty high. There's a risk. There's certainly a risk. So that's something you have to weigh. Okay. All right, great. Birarana 5 is saying, how long to approve a 212 waiver? How long to approve an I-212 waiver? It could take a long time. I'm going to say it's going to take more than a year. There's a whole process. It depends on where you apply for that I-212 waiver. So many of our clients that apply for this waiver, this is for people that have been ordered removed from the country. So let me go back. What is an I-212 waiver, right? What is an I-212 waiver? An I-212 waiver is basically permission to re-enter the U.S. for people that have received a removal order, right? So you've received a removal order and you want to come in on a visa and be allowed to re-enter for a short period of time. So that's what an I-212 waiver is. And the processing time, it can take over a year, because what happens is you apply for it. Most of our clients apply at the embassy with their visa application, and then the embassy takes that I-212 waiver application, sends it here to DC. They adjudicate it in DC, send it back, and then they move forward with the rest of the application process. So it can take a long time. So I would say, it's not something immediately that happens all the time, but so you should plan accordingly. Don't, make trips or anything like that. Let's see. Crystal says, I'm eligible for VAWA, but I don't want to leave my kids. So the good thing about VAWA, Crystal, is that you don't actually have to leave at all, right? So you don't have to leave as part of the VAWA green card process. If you want to leave later, if you are able to get work authorization and you decide later that you want to leave, you're welcome to do that, but you are not required. So you could decide if you wanted to stay in the marriage, stay with the kids, but what you would receive is work permit, social security number, authorization to travel outside the US, and also ultimately a green card. So that's the benefit of applying for VAWA if you're eligible. So if you are eligible and you are a victim of abuse from your spouse, you don't have to leave. You don't have to file a police report. Your spouse won't get in any trouble. You can still take advantage of these benefits. Of course, I'm going to emphasize, don't make up stories. We want to be truthful with everything that we submit to the government. Okay, but if you're in this relationship, you have so many benefits. Call us if we can help you. We're at 703-348-1663. Mohan says, good content. Thank you, Mohan. I hope you're doing well. I look forward to seeing you soon. This is one of my favorite people of all time. TikTok says, are you Indian? Yes. Well, I'm American, but I am of Indian descent. I was born in India. My parents lived in India. I grew up in Connecticut in the US, and now I live in the Washington, DC area. Gurpreet is saying, can I expedite my work permit based on marriage, right? Can I expedite my work permit based on marriage? No, unless you can show usually no, unless you can show there's some kind of financial burden or financial hardship, then you might be able to, but it's very, very hard to prove. So we've seen people try and be unsuccessful. So just know it normally takes about 6 months or so to get your work permit when you have a pending marriage-based green card application. All right, great. So Anthony said he followed us. That's awesome. Thank you. Just make sure if you think that other people might benefit from talking to an immigration lawyer, asking immigration related questions, that they should reach out to us, that you should share this post with them. Make sure if you don't already like our page, make sure you like our page, follow us on TikTok, and you can definitely get in touch with us and be notified every single time we go live. All right. Great. I think those are all the questions for today. Thank you so much. I look forward to seeing everyone again very soon. I hope the ones that have had a day off today, I hope you enjoyed it and got to relax. All right. Thanks so much. Bye.